the Foreign Intelligence Surveillance Act, I'm not a foreigner. Why should that bother me? What would you say?
Americans' communications are swept up in enormous volumes, so enormous that the government won't tell us how big it is because it would be a very awkward number for the government to disclose. I suspect that's the real reason. And those communications are available to FBI agents without a warrant or a court order of any kind.
And you talked about these backdoor searches, and that's been an intense focus of the committee. Could you help define that for folks so they understand the risk there?
Sure. What a backdoor search is an electronic query of data obtained under Section 702. So the communications are obtained. They are placed into data systems at the NSA and then shared with the FBI, the National Counterterrorism Center, and the CIA. And then agents can run electronic queries of those data systems using identifiers associated with Americans. So using an American's email address, for example, they can plug that in, and that will return any communications that were obtained under Section 702 that have an American on one end of them. And
it almost feels like there's a digital file out there about millions of Americans, and I'm sort of wondering how, and we've tried to get straight answers from folks who work in the government about this question, but what we've learned is it's upwards of 10,000 people who can conduct some of these backdoor searches. Have any of your studies evaluated the breadth of individuals who can engage in this violation of our civil liberties?
No, we don't know the number, but I think...
Isn't that scary? Shouldn't we? I mean, it seems like something we should know. How many people can do backdoor searches into information that was not collected pursuant to any probable cause or a warrant?
Yeah, it would be a good thing to know. And one of the reasons why I think we should be curious about it is because the government has told the FISA court that one of the reasons for all of these violations we've seen is that FBI agents didn't understand the standard for those searches. And that standard is that the search has to be reasonably likely to obtain foreign intelligence or evidence of a crime. Well, and that doesn't sound like rocket science to me. And that standard has been in place for 15 years.
But they break it. Well, I mean, I just read an order from the Foreign Intelligence, the FISC, the court, and the court said, well, you weren't just using these searches and queries to get legitimate law enforcement information. At times, people at the FBI were searching themselves, searching their ex-lovers, searching their neighbors in this system. And so it seems as though there's not a standard that's adhered to.
It's adhered to often in the breach. There were 278,000 violations of that standard in 2021.
I mean, if you've got 278,000 violations of the standard, as you've said, the breach is the standard in a lot of ways. So we have this tactical question coming up. We have FISA that is set to expire, and I believe we should let it. I believe the standard of violation of breach is so pervasive that the patient is not savable, that we have to design something totally different outside of 702. And then I have other colleagues who are like-minded in my desire to protect civil liberties, but who suggest tactically that the best approach is to try to insert strong warrant requirements. This is my 7th year in Congress. Mr. Kiko, I certainly don't have your experience, but I want to draw on it because I want to get your advice. I've gone down this road with the Cheneyistas and others who bring us to the precipice of reform, and then at the last moment, it seems as though the civil libertarians rarely prevail over those who purport to be defending national security, no matter how many violations of our liberties occur. And so would you advise a reform effort or an expiration strategy, and why?
Well, I would. That's a very tough question, and I know that's why you ask it. And I can actually see my preference would be some kind of reform effort with teeth and accountability, because there hasn't been any teeth and there hasn't been any accountability in the oversight that's been conducted. We're always at the end of the system. They say they're going to do something. It never gets done. 4 years later, we find out there's massive violations. Everybody comes, well, we're going to do it this time. But there's no accountability among the people that are breaking the law. There's no accountability among the administration. It doesn't matter. There's nothing.
Yeah, it sounds like there need to be penalties. Thank you for your testimony. I yield back.
Thank you. Chair recognizes the gentlelady, the ranking member, Ms. Jackson-Lee.
And thank the witnesses very much. Just a slight moment down memory lane, Ms. Goteen. Something called COINTELPRO. I won't ask you to get in the weeds, but it was used extensively against Dr. Martin Luther King and the whole landscape of civil rights activists and workers to give minimal liberties to African Americans during the 1950s and 60s. And so here we are again with what was needed to be able to protect Americans. And I think it's important to indicate that the process was that if there was communication and it was with a foreign operative, foreign citizen, the FBI for Americans would not be targeting you, not supposed to be, but we're targeting that foreign citizen or the communications thereof. How did we mess up so badly?
Wow, that's a tough question. What I would say is that FISA, as enacted in 1978, required the government to obtain an individualized court order showing probable cause that the target of surveillance was a foreign power or an agent of foreign power when domestically placing a wiretap to collect communications between even foreign targets and Americans. And that was to safeguard the Americans' constitutional rights that they have in that communication. What Section 702 did is it got rid of that requirement. And it enabled the government to say that as long as it's targeting a foreigner, we don't really have to worry so much about the Americans' constitutional rights. Now, that's not actually what Section 702 says. It says you're going to pull this in, the American side of the communications, but you should minimize it. You should delete it. You should not share it. Unfortunately, that's not what has happened.
So that is, that's a crux or one of the elements of the problem.
Absolutely.
There, this mountain piles up and no one feels any compulsion, not compelled to say, let me immediately send it into the incinerator, throw it into the trash, get rid of it, shred it, etc. Doesn't happen.
Right, and even if the FBI comes across Americans' information or other agencies, NSA, CIA, that doesn't even seem to be foreign intelligence or evidence of a crime, they pretty much never get rid of it until it reaches the age-off deadline, which is 5 years. It's 5 years with a lot of exceptions. So it's 5 years or in many cases much longer.
Let me try to hone in on what Americans may be impacted by with respect to these cases, this pile of information in which an agency has not complied with the guidelines that Congress put in place and or their own policies. To your knowledge, is the evidence found, or has the evidence found in this way, typically excluded in a criminal case?
Well, in most criminal cases, the government doesn't give the notice to criminal defendants that is required under FISA. There's been a long pattern of the government evading its notice obligations. And if the defendant doesn't know that FISA has been used, that Section 702 has been used in that defendant's case, there's no way the defendant can raise a challenge, let alone have the evidence excluded. And most likely the way that the government has been avoiding this notice obligation is through parallel construction, which is a well-documented practice of essentially recreating the evidence using less controversial means. So one of the things that Congress should do if and when it reauthorizes Section 702 is to prohibit parallel construction. If I could quickly speak to Congressman Gates's question, I think the problem with simply letting Section 702 expire is that
I will allow you to do so. The chairman's going to give me a little bit more time to be able to answer.
No.
But
I apologize.
if you'll go quickly.
I'll go very quickly, is that Congress will then lose the opportunity to make necessary reforms to other surveillance authorities and to close gaps that are in those authorities that allow the government to operate without any statutory authority at all. And if Congress merely lets Section 702 expire, the government will shift its surveillance activities to these other methods.
So let me quickly get from you the singular change, other than what we just talked about, parallel construction, that we should be looking at.
Gentlelady's time's expired, but you may answer that question.
If I have any message for you today at all, it's that you cannot just go with one singular change. A warrant requirement for backdoor searches is necessary. It is far from sufficient. There are other reforms that need to be made, not only to Section 702, but also to overseas surveillance that currently happens without any statutory authority, to the practice of purchasing Fourth Amendment protected information from data brokers, and several other reforms that I mentioned in my written testimony.
Thank you. I yield back.
Thank you. I recognize the gentleman from Wisconsin, Mr. Tiffany.
Yeah, thank you, Mr. Chairman. The subject of this hearing, Mr. Chairman, is fixing FISA, correct? And so, with all due respect, Mr. Kiko, I heard the comment you made that was along the lines of that both parties agree. On one of the most significant abuses of FISA, we do not have agreement, and that was in regards to one President Donald J. Trump. It was abused, and Mr. Durham highlighted what an abuse it was of FISA, and we have many people, including on this panel, that still will not recognize that, and that is dangerous for the American Republic, because if you have a Praetorian Guard that thinks they can take down a president, are we all free? Are we all free? Mr. Turley, building off from Mr. Gates's question, so let's say we don't authorize, what will happen? Let's say we didn't, will there be things that fill in the gaps? Do we have existing law?
Well, thank you for asking that question, because there is what economists sometimes call a path dependency that can set in with these types of programs, that you can't imagine not having 702. I can, because 702, and many of the members of this panel can, because we were here. You were in Congress. I was testifying when 702 was created. So there was an existence before 702, and Rome did not burn. That you have a system that can handle it. The question is whether Congress feels that these abuses are so serious that you want to use a rule that if you abuse it, you lose it. That is, this is not the first time the FBI has come before you and said, oops, we misunderstood the law. Oops, we did millions of improper searches. Oops, we actually violated the privacy of citizens in exactly the way that people said would happen. At some point, Congress has to decide whether 702 was a good path to take. If it decides to reauthorize 702, the solutions are very, very clear.
Mr. Turley, if the people are not honorable in those agencies, is it even fixable?
Well, part of the problem I had with Director Wray's testimony this week is when he talked about FISA, he kept on saying that was that earlier director. Well, the director may have changed, but the people in the FISA system have not. There's been a consistent culture of violations here that go back throughout the history of FISA. And this gets to, again, this sort of premise that was the flaw of FISA of trusting the government to act on good motivations. And I think that it's repeatedly shown, quite frankly, it cannot be trusted with that level of discretion.
Unfortunately, I only got 5 minutes here. You want to get a couple more questions. Mr. Scheer, Mr. Gates once again said tactically, what should the reforms be? What would be one reform that you would say needs to be done if Section 702 is left in place?
Well, several of us.
Turn your mic on.
Already, several of us have come up with a list of reforms, and there are over 25 of them. Perhaps the most important is the warrant requirement, the probable cause requirement that we discussed earlier. And if I could just briefly answer the question that you asked earlier, Congressman, as a former White House counsel lawyer. The answer that I would give to your question as to why it would be a mistake just to let Section 702 expire is that you then have a statutory vacuum, which the executive branch loves. If you're a lawyer in the White House or the Justice Department, you're going to ask, the question you're going to ask is, if we do this, will we be violating any law? And if there's no law on point, your inclination is going to be to ask, well, does the president have an inherent authority to do this thing that the intelligence community wants to do? And of course, they tend to read presidential authority broadly. And so if there's no statute that governs the issue, you're basically going to be opening the door to the White House and Justice Department lawyers to come up with creative
So you're concerned
rationales.
that we'd be ceding authority to the executive?
Absolutely.
Yeah.
And it's not their role.
So what if there was a penalty of removal of qualified immunity for somebody that abused this?
I think that's something that ought to be considered.
Okay, I got to get one more question in here. Ms. Goitine, Mr. Turley did a terrific job of anticipating my question. Did you hear the testimony of Director Wray?
I did not. I was busy preparing for this hearing.
Well, I would just say to you that you were incredibly prepared, and we really appreciate that. Mr. Chairman, I just want to say thank you for putting together this panel. It's one of the finest that I've been before.
Thank you. Thank you. They have notified votes. They've called them. What we're going to do here, just so everybody knows, is we're going to go to Mr. Nadler for his questioning, and then we're going to recess until after the votes, which would mean I would anticipate somewhere between 11:15 and 11:30 we'll be back in this room. Sorry about that interruption. And with that, Mr. Nadler, please.
Thank you. Let me first say that with respect to what Mr. Tiffany said, we may have a disagreement over whether FISA was abused in a certain case or not with respect to the former president. That doesn't affect our deliberations now. We all agree that FISA has been massively abused, and we've got to fix it. Mr. Kike, and the idea of eliminating qualified immunity here is a good one. I'd like to eliminate qualified immunity entirely. Mr. Keiko, in the 3 months since this committee last held a hearing on FISA, we learned that the FBI conducted unminimized warrantless backdoor searches of campaign donors, George Floyd protesters, and many others. If the FBI sought to search Americans' communications, no matter the reason, they would normally need a warrant under the Fourth Amendment. Could you briefly explain to us why the court has found warrantless searches of the 702 database to be acceptable under the Constitution? Mr. Kiko.
I don't think a warrantless search is acceptable under the Constitution, and that was what was anticipated when the Fourth Amendment was created.
No, we agree on that. My question is, why has the court found warrantless searches of the 702 database to be acceptable under the Constitution?
I haven't looked at that particular question, so I would ask a panel member to
Anybody else? Ms. Goitine?
I'd be happy to answer that. The FISA court has found that warrantless searches are constitutional. The FISA court has essentially said as long as the initial collection was lawful, then you apply some kind of lower standard to analyzing the queries rather than treating it as a separate Fourth Amendment event. However, Section 702 has recently made its way to the regular federal courts. And I say recently because for many years the government was not providing notice to criminal defendants, so there was no way to raise the issue. But in the past few years, regular federal courts have had a chance to look at this question, and there is a divide among those courts. You have 4 district court judges holding that these searches are constitutional, and then you have 4 appellate court judges expressing serious constitutional concerns. The only federal appellate court to rule directly on this question was a unanimous 3-judge panel of the Second Circuit, which held that you do have to treat the query as a separate Fourth Amendment event, subject to its own reasonableness analysis. And the Supreme Court has made clear that warrantless searches are presumptively unreasonable unless they fall within an established exception to the warrant requirement, such as consent or exigent circumstances. The Second Circuit remanded to the district court to conduct that analysis. So the courts, it is far from settled that these queries are constitutional.
And Mr. Ranking Member, could I just add one thing as well to that, and that is this was a reference to the Hasbarami case in the Second Circuit. and I agree with everything that was being said. One of the barriers that we see in federal court is that people have been denied standing in order to challenge these issues.
Yeah, Ms. Goitine, the number of searches conducted among U.S. person identifiers went from 3.4 million in 2021 to less than 120,000 in 2022. Can you explain what remedial measures the DOJ put in place to reduce the number, and whether you consider these changes sufficient to protect Americans from unwanted surveillance?
Sure. The FBI imposed some new training requirements, some new oversight requirements. It changed its data systems in various ways, and these changes resulted in the searches, as you say, going from 3.4 million to 200,000 searches. Now, I would say that one warrantless search of Americans' communications is too many. 200,000 warrantless searches, that's 500 warrantless searches for our communications every day. That is just a jaw-dropping number. And the fact that the FBI seems proud of that number really tells you how little regard they have for American civil liberties. They have made these changes according to the FBI's own internal study. Non-compliance has been reduced to 4%. I think there are a lot of reasons to question that number, but even if you accept that number, 4% of 200,000 searches, that's 8,000 searches every year that violate the FBI's own low standard.
Thank you, Ms. Goitine. How can FISA be modernized to protect Americans' communications that are inadvertently acquired through Section 702? What would be the impact of such changes on our national security? But how can they be? Right. What should we do, in other words?
Right. So I think the solution is to require a warrant or a FISA Title I order in order to conduct these queries. And the government has put forward absolutely no evidence and no reason to believe that that would harm our national security. After all this time, the government has managed to come up with 3 examples of situations where U.S. person queries were useful. The government has been very vague about exactly how those queries happened or were used and how they produced the benefit that the government is claiming. But more importantly, the government has given no reason to think that a warrant requirement or a Title I order requirement would have prevented the queries from occurring. So, for example, there's the Colonial Pipeline ransomware attack. In that case, the queries took place after the attack. So there would certainly be probable cause to support any query that would return evidence of a crime. And similarly, there were queries to try to identify and protect
the gentleman's time has expired.
Potential victims of assassination plots. And I would argue that surely these potential victims would have consented to a search had the FBI bothered to ask.
Thank you. I yield back.
Thank you. And again, thank you to the panel. Thanks for indulging us to go vote. And we hope everybody votes with me. Anyway, we'll be back probably about an hour-ish. And feel free to make yourself